Castillo? Speak up, please.
Yes, ma'am.
And Mr. Castillo's cases are set for trial to be in with juries? Okay. All right, you're Carly Davis. And this is 25 DCCR 1451 and 1452. What is the announcement?
Judge, we'd like to ask for maybe 3 or 4 more weeks. We're still reviewing discovery. In fact, I'm having a little bit of a discovery issue that I'm going to...
Okay, pause. A little bit of a discovery issue is lawyer speak for something didn't get turned over, and that can seriously affect how a defense is built. Think missing footage, unreturned lab results, or documents stuck in email limbo. And trust me, judges do not love discovery issues this close to trial. It's like showing up to a potluck without actually bringing a dish.
Figuring that out whenever I leave today.
Okay. And I know we were going to get some confirmation of non-narcotic medication. Where are we on that?
She did phase down. She went to a new doctor and they reduced the prescription. So she has phased down, and I do have proof of that. I can send it to Mr. Coleman, so he has it as well.
This right here is a quick but important compliance check. The judge isn't being nosy. When someone is on bond, especially in drug-related or behavioral cases, medication changes can matter for safety and supervision. A reduction in a controlled prescription? That's often a sign the defendant is meeting bond conditions and stabilizing. Basically, good behavior gold star.
I need you to, if you'll email that to me as well.
Okay.
I need that. I want that today.
Okay.
So get that to me and Mr. Coleman so that we know what's going on, what it was, what it is now, prescriptions, whatever you've got. And then we'll just do a normal reset to give you some time to get caught up on discovery and see if we can get an announcement. Is there any issues, Mr. Coleman?
No, Judge.
All right, Ms. Davis, make sure you stay in touch with Ms. DeLage, do everything you're supposed to be on bond, and then we'll see you back at the next court date. All right,
Thanks,
free to go.
Rhonda.
Thank you. See, Mr. Frank. Good morning. Are you Bethany Loza Diaz? Speak up, please.
Yes.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Loza Diaz, in cause number 25, DCCR 0928, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from December 4th of 2024. And how do you...
And here we go, a DWI with a child passenger is no small charge. In many states, it elevates a routine DWI to a felony automatically. Judges tend to go into hyperclarity mode during these pleas, making absolutely sure the defendant understands the consequences, because the stakes aren't just legal, they're parental, emotional, and in many cases life-altering.
...to that charge? Guilty. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Macon? Do you fully understand them?
Yeah.
Is there something you don't understand? Do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? So if I follow the agreement, you can't change your mind later. Do you understand? And so it looks like the agreement that you reached is for 2 years in the state jail prison, but instead of serving 2 years in the prison, you would be, that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding of your agreement? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objections, Your Honor.
It's admitted. Is there any evidence that Ms. Loza Diaz is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right over there. Okay? All right, we'll see y'all back at sentencing. Let's see, Ms. Norman on Charles Guidry Jr.
Yes.
Yes.
Okay. Y'all give me just a second. All right, you're Martin Ward. And so Mr. Ward was previously in court, entered a plea of guilty to that reduced offense of a Class C disorderly conduct, and that was for a fine of $250. Has that been paid?
It has, Judge. I have documentation in my file indicating that that has been paid.
All right, any reason not to go through with sentencing at this time?
Oh, no.
All right, Mr. Ward, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Yes,
There was actually no contest.
I'm sorry, okay. Your plea of no contest freely and voluntarily, find sufficient, and you did enter the probable cause the other day when we did this, right?
I believe I
I
did.
feel like we did.
I feel like we did.
Okay, I'm almost positive.
Blink and you'll miss it. This is one of those rare courtroom unicorns, a straightforward, uncontested misdemeanor sentence. No debates, no drama, no curveballs. When the judge says $250 fine, that's it. You can practically hear every public defender in the county whisper, if only all cases were this easy.
Positive we did. If not, then we can take care of that, but we'll double check. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class C misdemeanor of disorderly conduct. Sentence you in accordance with your agreement to a term of $250 fine that's already been paid. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived any right to appeal. You'll give me just a second, that's printing out, and then you'll be free to go, sir. $250 fine. That's it. That's it. Yeah. And it should. Is something printing? Okay. You're gonna step over in front of the clerk, and she'll give you that certification.
Thanks, sir.
Thank you.
Thank you, Judge.
See, Good morning. You're Ramadan Castillo. Speak up, please.
Yes, ma'am.
And Mr. Castillo's cases are set for trial to be a jury selection next Monday. What is the announcement?
Right here.
All right. Obviously, it is likely that this will be at the top of the list. After today, there will be no plea bargains accepted.
Ooh, here's the heat. No more plea bargains after today. That's the judicial version of doors are closing, last call. When a judge sets this line in the sand, everything shifts. Defense attorneys scramble, prosecutors lock in positions, and defendants suddenly.
Everybody needs to be prepared to go. Stay in touch with Mr. West. He will know after docket today the trial order, but anticipate seeing you back next Monday afternoon at 1 o'clock. Good morning. Are you Charles Darling? And this is 24 DCCR 1384. Mr. Darling's case is set for trial to begin with jury selection next Monday. What is the announcement?
States Attorney, Your Honor, I would like the record to reflect I have sent letters and subpoenas to all known addresses for the complainants.
Okay. And do you anticipate there being an issue potentially?
Possibly that's why I wanted to let the court know in advance.
Okay. So then what I'll do, I'll number the case at the probably close to the top so that it gets taken care of one way or the other. If she doesn't show, we're not going to just reset it for that. Since she sent that out, we'll get it figured out Monday. If she does, then obviously, depending on that order, the case could go to trial.
Okay.
Okay, thanks. Let's see, Mr. Smith, Diamond James. Good morning, ma'am. You're Diamond James. And Ms. James is charged with hindering apprehension or prosecution of a known felon. And what is the announcement?
Judge, I've been talking with Mr. Smith about a possible resolution for this matter. If we could get one more setting, I think we'll have it disposed of.
All right. It looks like you were just appointed at that last court date. Okay. Any issues, Mr. Smith? All right. So, Ms. James, I'm going to reset your case one more time. Make sure you stay in touch with Mr. Lewis so he'll tell you when to be back and you guys can visit about the case before you come back. Okay? All right. You're free to go. Yes, sir. And you've got Michael Thomas. Sorry, you're Michael Anthony Thomas Jr.? Yes. And this is 23 DCCR 0530. Mr. Thomas's case is set for trial to begin with jury selection next Monday. What is the announcement?
Judge, I would be able to announce I'm ready, but there is one issue. Evidently, there was a TRO hearing that was done recently in regards to these allegations. I'm not representing him on the family law case down the hall, but he did bring me some documentation in regards to that, but I understand it was on the record, and I would like a chance to get the transcript, especially given the testimony about the complainant.
Okay. I would think you would want that as well, probably. So why don't I do this? Why don't I reset it to just a review docket? You guys can both get that
Okay.
transcript, and then if it changes something, then we can revisit. I know this was a plea that was rejected. If
right.
there's something that changes and we go back to something, then you guys can let me know. Otherwise, we'll put it back on the trial docket after that if it's not worked out.
All right.
Stay in touch with Mr. Lewis, and then he'll let you know when you need to be back, okay? And if you'll just make a note that they're getting a transcript of. Good morning. Are you Charles Guidry Jr.?
Yes, ma'am.
And Ms. Norman, will your client waive the formal reading of the indictment?
He will.
Mr. Guidry, in cause number 23-41646, you're charged with the state jail felony offense of theft in aggregation amounts from January 1st of 2022, continuing through June 30th of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Norman? Do you fully understand them? And do you understand, if I follow the agreement that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to pay restitution, and that amount, I guess, needs to be determined.
No, well, actually, Judge, I have an amount here. That amount would be